Good evening and welcome to Unacademy, a one stop destination for the English medium civil services aspirants. Welcome to stage 4 of Conquer Prelims 2025. In stage 1, we discussed current affairs topics of the period January to May 2024. In stage 2, we discussed various high yielding topics for their relevance for the prelims examination. For example, in Indian polity, I discussed the entire Bear Act in 3 sessions of close to 11 and a half hours. In stage 3, we discussed the PYQs of the last 10 years. And today is the session 1 of stage 4 of Conquer Prelims 2025, where we will discuss current affairs of the period June 2024 till April 2025, relevant for your prelims examination. After the session is over, I will share the PDF on my Telegram channel. The link to join the Telegram channel is provided in the video description. Now, let's get started and let's look at topic number 1. States have the right to levy tax on mineral rights. But before we start, let me tell you something very important. When it comes to polity for your prelims examination, what sort of questions are asked in the exams? If the office of governor is in the news, then the provisions in the Indian constitution regarding the office of governor can be asked. For example, if ethics committee was in the news last year, that is why we saw a question on the ethics committee. So in polity, when we look at current affairs, if there are some developments which have taken place which are in the news consistently, the provisions related to the static portion of that current affairs would be asked in the examination. Clear? Let's look at topic number 1. A lot of judgments have been given by the Supreme Court last year, which has further strengthened what we call fiscal federalism, wherein more powers have been given to the states by the Supreme Court. And this is a very important judgment where the Supreme Court, by the majority of 8 is to 1, a 9 judge constitution bench of the Supreme Court had to decide this issue, and 8 judges ruled in favor. There was only one dissenting judge, Justice Nagaratna. And the Supreme Court said that states have the right to levy cess on what we call royalty that they were charging from companies. And at the same time, the states have the power, the right to tax the lands which comprise of mines and quarries. From this topic, it's a very important topic specifically for the mains examination because, as I told you, it strengthens fiscal federalism in India. But from the prelims perspective, how is this topic relevant? That's something that we need to understand. For example, look at the question on your screen. Which of the following subjects are part of the union list under the 7th schedule of the Indian Constitution? When the nation was under a lockdown because of COVID-19 pandemic, then interstate quarantine is under which of the following list? State list, concurrent list, union list? That question was asked in the examination. So if there are some important judgments given by the courts, let's say on industrial alcohol, let's say on tax on minerals, that's something that we need to understand. Who has the competence? Under which list are these subjects? Look at the question on your screen. Alcoholic liquors for human consumption, fisheries, betting and gambling, intoxicating liquors. Which of these subjects are part of the list 1, union list? None of the above, because all these are under the state list, list 2 of the 7th schedule. If it is fisheries beyond the territorial waters, then that matter comes under union list. But fisheries comes under state list. If it is fishing beyond the territorial waters, that's the subject matter of the union list. States have also told, Supreme Court has also told that states have the power to tax industrial alcohol as well. Again, another judgment given by the 9 judge bench of the Supreme Court, which further, as I said, strengthens fiscal federalism. But let's understand this topic in great detail. What is a royalty? For example, I am a music composer, music producer. I have produced a music. Now, there are online music streaming companies which may want to use this music which I have composed. In exchange for that, I will get royalty. So, what is a royalty? Royalty is a fee which is paid to the owner of a product in exchange for the right to use that product. So, if my music is being used by online streaming, music streaming companies, I will get the royalty. If I write a novel, the number of sales that I get on top of that, I will get the royalty as well. Now, what has happened is there is entry 52 of list 1, which says industries. For example, if there is an industry, Parliament enacts a law and says that the control of this industry should be given to the union. In what aspect? In public interest. Any industry, if the Parliament enacts a law and says that the control of this industry for larger public interest should be given to the union, that industry will be under the control of the union. That's entry 52. Similarly, entry 54. If you notice Schedule 7 of the Constitution in detail, regulation of mines and mineral development comes under union list. But mines and mineral development also comes under state list. So, what is the difference between the two? Listen to me carefully. Entry 54 of list 1 of union list says regulation of mines and mineral development will be under union list. And because of that, a law was passed called Mines and Minerals Development and Regulation Act 1957. According to this law, royalty can be given to the states because, for example, if there is a company which has been given the right that you can extract minerals from this land, then this company will have to pay royalty to the states because, after all, land is within that state. But you could have only charged royalty. You could not have imposed any further tax on these lands, despite the fact that land is under the state list. Similarly, when it comes to state list, it says taxes on mineral rights is under state list. So regulation of mines and mineral development is under union list. But taxes on mineral rights is under state list. Constitution further says that this right of the state to tax minerals will be subject to the law passed by the parliament because parliament has the power to regulate mineral development. Similarly, there is entry 23 of list 2 state list which says the regulation of mines and mineral development is also under state list but subject to the law passed by the parliament. And parliament used these powers under the union list to pass this law, to enact this law in the year 1957. India Cements, it was given a contract to extract mines from Tamil Nadu. Tamil Nadu imposed cess on royalty. Because under this law passed by the parliament in 1957, the states can get royalty because these minerals are being extracted from the lands which belongs to the states, but you can't impose tax because for that there is already a parliamentary law passed in 1957. What you can charge is royalty. What the government of Tamil Nadu did, it imposed cess on royalty. Cess is a tax for a specific purpose. Matter went to the court. The Supreme Court said, a 7-judge bench of the Supreme Court said in 1989 that states can't do that because there is already a parliamentary law which regulates the development of mines and mineral development. Since there is already a parliamentary law for that, the states can only charge royalties, but states cannot impose further tax or cess on these royalties. This was the case which was decided by the Supreme Court in 1989 because the Supreme Court said that union has the authority over regulation of mines and mineral development. Why? Because for that we have entry 54 of the union list of list 1 of the 7th schedule. Further, what Supreme Court said, states have the power only to collect royalties, but you can't impose further tax on these royalties. And then something else Supreme Court said in 1989. Supreme Court said, we are of the opinion that royalty is a tax. This is where in 2004, another Supreme Court judgment, another Supreme Court bench was hearing this case because this matter went to the court again. Because other states also enacted the same laws, started imposing cess on the royalty that they were charging. Supreme Court said that maybe there is a typo. Royalty is not a tax. Because if I am the producer or composer of a music, or I'm writing a novel, I'm an individual, I can charge royalty, but I cannot impose tax because tax is the sovereign power of the state. Only the state can impose taxes. If you are saying royalty is a tax, that means private individuals are also then sovereign, imposing taxes on the people, those who are using your products. This is what led to another bench of the Supreme Court. And now a nine-judge bench of the Supreme Court had to decide what is the correct legal position on this. Because Supreme Court said that maybe there is a typographical error. It should not have been royalty is a tax. It should have been cess on royalty is a tax. But can states impose tax on mines and minerals extracted from their lands? No, because there is already a parliamentary law of 1957, which means this is under the exclusive control and the authority of the union of the central government. And nine-judge bench of the Supreme Court decided and ruled that no, states have this power. So states have the power that you can impose cess on royalty as well, and you can also impose tax on those lands which are bearing minerals because land is under the state. So, from this topic, what you need to understand, maybe you need to understand what is this concept of a royalty. You need to understand entry 52 and 54 of list 1, which is union list, because you never know what sort of questions can be asked in the examination. Maybe something of this sort can be asked in your examination. And then you also need to understand what was the issue in 1989 when the seven judge bench of the Supreme Court said, no, this is the power with the union, not with the states. States can only collect royalties, they cannot impose taxes. But then last year, a nine judge bench of the Supreme Court, headed by Chief Justice of India, Justice Chandrachud, said, no, states have the power to impose cess on royalty. You also have the power to impose tax on lands bearing minerals. That's something that you need to understand from this particular topic. Then another significant judgment was, again, a nine judge bench of the Supreme Court had to decide whether the states have the power to impose tax on industrial alcohol. Listen to me carefully. The previous judgment that we discussed, this was one of the second longest running cases in the history of independent India. This case was finally decided by the courts after 9,044 days, although not relevant for your exam, but you never know what can be asked in the examination. This was the second longest pending case in the Supreme Court, which was finally decided after close to 9,000 days. Then states have the power to make laws on industrial alcohol. What you need to understand from this topic, Constitution uses three distinct expressions relating to alcohol. One is intoxicating liquor, the other is alcoholic liquor for human consumption, and then there is intoxicating drinks. What is this industrial alcohol? It was long established that states have the power to levy tax on alcohol for human consumption. This is where excise duty was imposed on the alcohol which is used for human consumption, intoxicating or liquor for human consumption. There was a judgment given by the court wherein the court said previously that only parliament has the power to impose tax on industrial alcohol. And what is this industrial alcohol? It is basically ethanol, but this ethanol is mixed with, let's say, chemicals, let's say toxins, and this process is what we call denaturation. And this is how you convert this ethanol into non consumptible alcohol, which means now this denatured alcohol will be used for chemicals, will be used in pharmaceutical industries, will be used in perfumes, will be used in cosmetics, will be used for cleaning the surfaces, disinfectants. But this you cannot use for consumption because this process of denaturation makes it unfit for human consumption. What states told the Supreme Court that we should also have the power to impose tax on industrial alcohol. Why? Because even this industrial alcohol can be consumed by the people. And this is how a large number of people also die because they consume this illicit liquor. So, this liquor can also be consumed by the people. So, if this is a liquor for human consumption, we should have the power to impose taxes on industrial alcohol as well. Supreme Court said there is a distinction. Liquor may not always lead to inebriation, but liquor can also be used as an intoxicant when it is consumed by the people. For example, this denatured alcohol. This is where we are giving rights to the states that now states alone can impose tax on industrial alcohol. Long story short, prior to this judgment, again, this was a nine-judge bench judgment, and there was again a dissenting judge, Justice Nagaratna, which means this judgment was given by the majority of 8:1. Eight judges said states have the power to impose tax on industrial alcohol because previously this power was given to the parliament. This power was given to the union government. And for that, you also need to understand that constitution uses three distinct expressions for alcohol. One is intoxicating liquor, the other is alcoholic liquor for human consumption, and the third is intoxicating drinks. Let's look at topic number three. And listen to me carefully. Both these topics that we have covered are very, very important for mains examination. But for the prelims examination, you just need to understand on which items states were given the power to impose taxes: industrial alcohol, cess on royalty, tax on lands bearing minerals, which these from these lands you are basically extracting minerals. This power has been given to these states, which further boosts or gives fillip to fiscal federalism. Then topic three: is Aligarh Muslim University a minority educational institution? We don't know as of now. What the Supreme Court has done, a seven-judge bench of the Supreme Court gave the judgment by the majority of 4:3. Four judges were in favor, three were against. What Supreme Court said? That we will lay down a test, a holistic and realistic test to determine the minority character of an educational institution. And it is this judgment of the Supreme Court which will be used by a three bench of the Supreme Court, three judges bench of the Supreme Court to decide whether AMU is a minority educational institution or not. As of now, we don't know whether AMU is a minority educational institution, but what the seven-judge bench of the Supreme Court has done, it has laid down a holistic and realistic test to determine the minority character of a minority educational institution. For that, we need to understand what is Article 30 of the Constitution. When we look at Article 29 and 30 of the Constitution, it talks about cultural and educational rights. And Constitution then uses the term minority. But you also need to understand that this term minority is not defined in the Constitution. That's important fact number one. But Constitution does say under Article 30 that all minorities, whether based on religion or language, the Constitution recognizes minorities on two grounds, either on the grounds of religion or on the grounds of language. For example, Dr. Ambedkar in the Constituent Assembly said that if there are Marathis and these Marathis have migrated to Tamil Nadu, they will become linguistic minorities in Tamil Nadu. And these linguistic minorities or minorities, they have been given an important fundamental right, which is the right to establish, manage, and administer educational institutions of their choice. Whether you want to establish a technical institution or a professional institution or a school or a college, that is the right of a minority. How is it different from other important rights? For example, is right to property a fundamental right? It's not a fundamental right. It used to be a fundamental right till 1978, but 44th Constitutional Amendment Act was passed in 1978. Now, right to property is no longer a fundamental right. It is now other constitutional right under Article 300 capital A. But listen to me carefully. This right to property is still a fundamental right for a minority educational institution. Because Constitution says when the state wants to acquire property or land belonging to a minority educational institution, the state has to provide compensation in such a manner that when you provide compensation to this minority educational institution, it should not restrict or derogate their rights under this article, which means they should be in a position to fulfill their right, to exercise their right of managing, administering their educational institution of their choice. So, right to property is still a fundamental right for a minority education. And Constitution further says that when the state is giving funds to educational institutions, it should not discriminate on this ground that we will not give funds to this institution because it is a minority educational institution. No, that you can't do. That means state, while granting funds, cannot discriminate amongst the educational institutions merely on the ground that this is a minority education. And you would know that these minority educational institutions, they have a lot of protection in the sense they have a lot of freedom in the recruiting, teaching, and non-teaching staff. They have a lot of freedom in terms of reserving seats for their own community. And Supreme Court has said that these minority educational institutions, they can reserve up to 50% of the seats for their own community. And when it comes to caste-based reservation, for example, reservation in educational institutions for SCs, STs, OBCs, also for economically weaker sections of the society. This reservation does not extend to minority educational institutions because minority educational institutions have been kept out of the fold, out of the purview of these caste based reservations. So, what is a minority educational institution? That you have to keep in mind. Now, the question before the court was what about AMU? Although it was established as Mohammedan Anglo Oriental College when it was established by Sir Said Ahmad Khan, and then it was converted into a university. And then a law was passed in 1920 to establish Aligarh Muslim University. And you would know that in Schedule 7 of the Constitution, under Union List, there is a special mention of Banaras Hindu University, Aligarh Muslim University, Delhi University, Hyderabad University under Article 371, capital E. So these are considered to be universities of national importance. Matter went to the court whether AMU is a minority educational institution or not, because after all, it has been established by the law passed by the legislature. Because there was a time when there was a university court. This university court, which was managing this university, was all comprising up of Muslims. Later, the President of India nominated members to this university court. Then there was a court judgment known as Aziz Basha, where Supreme Court said that AMU is not a minority educational institution. Then another law was passed by the parliament to confer minority status on AMU. Then something else happened in the early 2000 when Aligarh Muslim University decided to reserve 50% of the seats in PG medical courses for the Muslim community. All these things were challenged before the Supreme Court, and it was challenged before the court. How can you restore minority educational institution status on the Aligarh Muslim University? Supreme Court said before we decide whether AMU is a minority educational institution or not, we will decide what is the test, a holistic, realistic test that judiciary will perform to determine the character of an educational. Long story short, again, there are lots of things under this which can be relevant for your mains examination. But for the prelims examination, what you need to keep in mind is what is this case all about? The Supreme Court has not yet decided whether AMU is a minority educational institution. Full stop. What Supreme Court has decided, it has laid down a test to determine the character of an institution. And now this test will be used by a three-judge bench of the Supreme Court to decide whether AMU is a minority educational institution or not. For prelims examination, what you need to keep in mind, what is Article 30? Right to property is still a fundamental right for a minority educational institution. In a minority educational institution, there is no caste based reservation. There is no reservation for economically weaker sections of the society. In fact, these institutions have a lot of autonomy when it comes to hiring the teaching and non teaching staff. But what is this test? What is the issue? If in Aziz Basha case, Supreme Court said AMU is not a minority educational institution. Parliament amended the law and conferred minority status on AMU. Then AMU decided to reserve 50% of the seats in PG medical courses for Muslims. This matter went to the court, and now the Supreme Court has laid down a test. And what Supreme Court has said, when an institution is established, this institution can be established for the conservation of language and culture. But it need not be the only purpose. Because the Supreme Court was told by the central government that although Aligarh Muslim University's predecessor was Mohammedan Anglo Oriental College, but this was not established to conserve the language or culture of the Muslim community. Because this university was established to provide modern education where Voltaire would be taught to the students. So, since it was not established for the conservation and preservation of language and culture, as such, it is not a minority educational institution. Supreme Court said if an institution has been established, yes, the basic purpose may be for the conservation of language and culture, but that may not be the sole purpose. That may not be the sole objective. Number one. Number two, if a minority educational institution is accepting or admitting students belonging to non minorities, that does not mean it will lose its minority character. Third, Supreme Court said if in an educational institution secular education is taught, secular education is imparted, for example, science, humanities, social sciences, literature, that does not mean that it will dilute the minority character of that institution. What Supreme Court said, we have to look at three things. Number one, what is the origin of this institute? Who was the brain behind establishing this institute? In whose mind the seeds of this institution were germinated? So we have to look at when we have to test whether a university X or an institution X is a minority educational institution or not, we have to perform three tests. Test number one, what is the origin of this institute? What was the purpose of its establishment? How the idea was finally implemented? In a sense, the purpose of establishing this institute must predominantly be for the benefit of minority community. If there is an institution which has been established And the purpose was this establishment should be for the benefit of our own community. Then it is a minority educational institute because test number one has been satisfied. Even if other students are also admitted, even if non minority students are also admitted, that doesn't mean it will lose its character of a minority institute. That's test number one. Second, who implemented this idea? The first was how the idea was born, then how this idea was implemented, who contributed funds for the establishment of this university, who got the necessary permissions to establish, implement this idea. That is test number two. And test number three, we have to look at the time of the commencement of the Constitution, 26th January 1950, who was in charge of administering this institute? If it was the minority community itself, then it's a minority institute. If later on the control of establishing, the control of managing this institution was given to the state, that is irrelevant. But at the time of the commencement of the Constitution, who was administering this institution? If it was the minority education, if it was the minority community itself, then it's a minority educational. These three tests have been established, can be used by the Supreme Court to determine the character of an educational institution. This is something that you have to keep in mind. Any questions? Okay. Let's look at topic number four, Post Office Act 2020. This Post Office Act of 2023, it has replaced what? A 125-year-old law called Indian Post Office Act, which was passed in 1898. What are the important provisions of this law? Let's understand them. Section 9 of this act, it gives power to the center, to the union government. That union government, what you can do? You can empower any officer. For example, you are sending a parcel from one place to another place and you are sending it through India Post. Power has been given to the union government that you can empower any officer, that you can intercept, open, or detain any item. But on what grounds? These grounds are very important. Grounds mentioned are in the interest of the security, friendly relations with foreign state, public safety, public order, because these are the grounds which are mentioned under Article 19, Clause 2 as well. But one term has been added, which was also part of the 1898 law. It's called emergency. That means union government has been empowered that you can empower any officer, and this officer who has been empowered can intercept, open, or detain this item. On what grounds? Public safety. On what grounds? Public order. On what grounds? Emergency. But this term emergency has not been defined under this Post Office Act of 2023. Number two, if this parcel has been opened, now the officer has the power that you can hand over these items to the custom department as well. And the custom department will then decide whether these items are liable for the imposition of the customs duty. This is another important provision of this law. What if these post office officials, they are committing fraud, misconduct, or they are indulging in theft? No such penalty will be imposed on them, because there used to be penalties under the 1898 law if the post office or post office officials would resort to corruption, would resort to misconduct, will resort to theft. Now, all these penalties have been removed from 2023 law in its entirety. That's another thing that you have to keep in mind. Another important thing is Section 4 of 1898 Act, India Post, had exclusivity. Listen to me carefully. Who had the power, exclusive power, to send letters from one person to another person, from one area to another area? This was the exclusive power of India Post. That means India Post had the exclusive jurisdiction to transmit these letters. But now the point is, what are these letters not defined in the law? When it is not defined, then we saw the emergence of private courier services. For example, Blue Dart, DTDC, and others. We saw the emergence of these private courier services. Letters can be transmitted from one place to another only by India Post. That is why these private courier services, since this term letter was not defined, they are saying that we are not transmitting letters. We are not delivering letters. We are delivering parcels. We are delivering documents, because this term letter was not used, was not defined. Now, what the parliament has done by enacting this Post Office Act of 2020, it has removed the exclusive jurisdiction of India Post in conveying letters. That means now private courier companies, they no longer have to say we are delivering parcels or documents. They can also say we are delivering letters, because now the exclusivity has been removed. Another important point: what if there are lapses in the postal services? For example, your document has been lost, your parcel has been lost, your letter has been lost. Previously, there used to be liability. Although 1898, this 1898 law, there was no broad liability for Post, India Post, except if it was written. Previously, under the 1898 law, unless and until it was expressly written that we have the liability in case we are indulging in lapses in delivering these parcels or documents. But now, this 2023 law, what it has said, it has completely exempted India Post from any liability for lapses in postal services. But yes, liability may be prescribed if the rules are made by the central government. So, central government, and this is what we call delegated legislation. Central government will make rules, bureaucrats will make rules to prescribe liability in case there are lapses in these postal services. And this is where some experts argue that it leads to conflict of interest, because rules will be prescribed by central government. India Post comes under central government. Why would central government prescribe rules for liability against its own organization in case there are lapses? So that is the criticism for this law. But be that as it may, these are the facts. These facts can be important for your prelims examination. Now, let's look at the question on the screen and answer in the comment section. Which of the following statements is or are correct? The Indian Post Office Act of 1898 is the central law governing post offices in India. Under the existing law, the central government has the exclusive privilege over conveying letters. The government has the power to intercept an article transmitted through India Post on only the grounds mentioned under Article 19, Clause 2. Under the existing law, India Post is exempted from liability for lapses in postal services. Let me know what is the right answer. Okay. Which of the following statements is or are incorrect? The Indian Post Office Act of 1898 is the central law governing post offices in India. It's incorrect. Why? Because this law has been replaced by the law passed in 2023 Act. Under the existing law, the central government has the exclusive privilege over conveying letters. Now, what is the existing law? 2023 law. It has removed the exclusivity of the India Post from conveying letters. There was exclusivity under the 1898 law, but not under the existing law. So, this is also incorrect. The government has the power to intercept an article transmitted through India Post on only the grounds mentioned under Article 19, Clause 2. No, under Article 19, Clause 2, there is no mention of emergency. There is no mention of public safety. Although public order is mentioned, but not public safety. So this is also incorrect. Under the existing law, now which is this existing law? 2023 law. India Post is exempted from any liability in lapses in postal services. This is correct. But the question is asking which of these statements are incorrect? C. Three statements is the right answer. Okay, great. Let's look at another topic, ordinary laws versus constitutional amendment acts. In AMU case, something important was told by the Supreme Court, conveyed by the Supreme Court. And for that, first I will display the question on your screen, and you have to tell me what is the right answer. An ordinary law can be challenged before the courts on the grounds of one, violation of the basic structure, law being beyond the legislative competence of the authority which enacted it. Three, violation of the fundamental rights. Select the correct code from below. Only one and two and three, all of the above. What is the right answer? B, C. Okay. An ordinary law can be challenged before the courts on the grounds of violation of the basic structure? No. Law 2 and 3, C is the right answer. Why? Because this again was told by the court in the AMU case. What Supreme Court said that here is an ordinary law passed by the parliament. And then there is a constitutional amendment act again passed by the parliament, but under Article 368 of the Constitution. Yes, this constitutional amendment act can be challenged on the grounds of violating the basic structure doctrine. For example, when 99th Constitutional Amendment Act was passed in the year 2014, which relates to NJAC. NJAC is also in the news because of the uh, controversy surrounding the Delhi High Court judge who has now been shifted back to his parent High Court, the Allahabad High Court. So the idea was that in 99th Constitutional Amendment Act, NJAC would replace collegium. So whatever task is performed by the collegium system in India, that will be replaced by the NJAC, National Judicial Appointments Commission. For example, now who will recommend the appointment of the Chief Justice of India or the appointment of the judges to the Supreme Court, judges to the High Court, transfer of a High Court judge from one High Court to another High Court? If this is done by the collegium, it should be done by National Judicial Appointments Commission, NJAC. And NJAC would consist of Chief Justice of India, two senior judges of the Supreme Court, law minister, the union law minister, and two eminent persons. And these two eminent persons will have to be selected based on the recommendations of a committee. And this committee will consist of Prime Minister, leader of the opposition in Lok Sabha, or the leader of the single largest party in the Lok Sabha, and the Chief Justice of India. When this Constitutional Amendment Act was passed, it was challenged before the court, and the Supreme Court in 2015 said this NJAC is unconstitutional. Why? Because it violates the basic structure. Which basic structure? It violates independence of judiciary, and it also violates primacy of Chief Justice of India in judicial appointments. The Supreme Court said we have a problem with the involvement of the union law minister. The mere presence of the union law minister compromises the independence of judiciary, hence NJAC is unconstitutional. And under the current collegium system, Chief Justice of India enjoys a virtual veto. Virtual veto in the sense, if in collegium system we have a chief justice and four senior judges of the Supreme Court, if these four senior judges are in agreement upon a name X, that yes, X should be recommended to the president for appointment, but Chief Justice of India is not in favor of X, this name cannot be sent to president for appointment, because any name which is not acceptable to Chief Justice of India cannot be sent to president for appointment, which means that in the existing collegium system, Chief Justice of India enjoys a virtual veto, which was not there in case of NJAC. Because in NJAC, Chief Justice of India does not have a veto. Since it violates primacy of Chief Justice of India in judicial appointments, which is also part of the basic structure, Supreme Court said NJAC is unconstitutional. That means 99th Amendment is unconstitutional. So Constitutional Amendment Acts passed by the Parliament under Article 3, it can be challenged on the grounds of violating the basic structure. But when it comes to ordinary laws, you can challenge ordinary laws on only two grounds. One, if they violate fundamental rights, because you can trace this concept directly from Article 13. Because Article 13 says the state shall not enact any law which can delete or modify or abridge fundamental rights. And if such a law is enacted by the state, it will be declared null and void. That means whenever the state passes an ordinary law, whenever the parliament or the legislature enacts an ordinary law, it can be tested on the grounds whether it is violating the fundamental rights or not. And second, if this law is beyond the legislative competence of that authority. What does that mean? For example, Karnataka Legislative Assembly is enacting a law on currency or enacting a law on extradition or enacting a law on citizenship. Can a state legislature enact a law on citizenship, currency, extradition? No. Why? Because these are under the control of the union. Can parliament enact a law on police? And if such a law has been passed, it will be declared null and void because police is under the state list. So whether you have the legislative competence to enact such a law, on these two grounds only, the ordinary laws can be challenged before the court. This was told by the Supreme Court in the Raj Narayan case way back in 1975. Because at that time, the Chief Justice of India, Justice A.N. Ray, said, if we test an ordinary law on the grounds that it violates the basic structure, it may amount to rewriting the Constitution. That is why we should not test ordinary laws on the touchstone of basic structure. And the same thing was told by Chief Justice of India, Justice Chandrachud, in the AMU case as well, saying that these terms such as secularism, parliamentary democracy, these are vague terms, undefined terms, and if we test ordinary laws on the grounds of violating the basic structure, we may then rewrite the Constitution. That is why ordinary laws, long story short, can be challenged on only two grounds. One, if they violate fundamental. Two, if it is beyond the legislative competence of the authority which enacted it, not on the grounds of violating the basic structure. Clear? Done. Now let's look at topic number 6, statutory bail. The jurisprudence is as laid down by the Supreme Court in the late 1970s, when Justice Krishna Iyer and various other judges, they laid down that bail is the norm, jail is the exception. As much as possible, you should release the accused on bail. In extreme circumstances, exceptional circumstances, you should keep them in jail, because bail is the norm, jail is the exception. Jail becomes exception where? If the accused has the potential to threaten the witnesses, if the accused is at a flight risk, if the accused may tamper with the evidence, if the judges feel that this accused, he is at a flight risk, that means maybe he will become another Vijay Mallya, he will run away from this country, and then it will become very difficult for him to be extradited to India, then keep him in jail. Don't release him on bail, because bail is normally a norm, but jail is exception, and this is the exceptional circumstance. If this accused can tamper with the evidence, if the accused can threaten the witness, in these extraordinary, exceptional circumstances, bail should be rejected, jail should be given to these individuals. But there are some laws which turn this jurisprudence upside down. For example, there is a law related to unlawful activities called Unlawful Activities Prevention Act, UAPA, or there is a Prevention of Money Laundering Act, PMLA. Under these special laws, that what we call special laws, jail is the norm, bail is the exception. For example, if you are accused of money laundering under the Prevention of the Money Laundering Act, bail can be given to you only if you satisfy conditions under Section 45 of this PMLA Act, PMLA law. And that is what we call satisfying the twin conditions. Twin conditions in the sense, if you are accused under PMLA, you can be granted bail only if you satisfy two conditions. Which are these two conditions? Number one, the judges are of the opinion that prima facie, at the face of it, you are not guilty. And number two, you will not commit any other crime. If I'm accused under PMLA, I will be granted bail by the judges if the judges feel that I am not guilty. But that is something which is a matter of trial, where I have to present my argument, I have to defend myself through my lawyer, where the state also has the power to defend itself. So it's normally you are bringing the element of trial at the bail stage. That's why it becomes very difficult to get bail in PMLA cases. And second, if the judges are confident, sure, that you will not commit any other offense. But what we have witnessed over a period of time is that the Supreme Court has ensured personal liberty even under these laws. For example, one person was released on bail under PMLA
because the court said since you have already spent a lot of time in the jail and there is no chance or no likelihood of the early trial in this case, we will release you on bail. Ms. K. Kavita of Bharatiya Rashtriya Samiti, she was released on bail in PMLA cases. Why? Because the court said, since you are a woman, we will release you on bail. Because these twin conditions can be relaxed if you are less than the age of 16, if you are a woman, if you are suffering from some terrible diseases. In such conditions, we can release you on bail even if you are not meeting these strict twin conditions under PMLA. That is a bail in special laws, for example, UAPA or PMLA. But what is a statutory bail? Statutory bail is, for example, there is section 436 capital A of CRPC. Now, sir, CRPC has been replaced by Bharatiya Nagarik Suraksha Sanhita, BNSS. Even in BNSS, there is a similar provision. The provision that was there in CRPC under 436 capital A, there is a similar provision under section 479 of BNSS. What is this provision? The provision is, if you have been accused of a crime for which, let's say, the punishment is 7 years, but if you have already served half of that jail term, you are still an accused. But if you are declared guilty, your maximum punishment is 7 years. But if, as an accused, as an under trial, you have already served more than half of this prescribed jail term, then you can be released on statutory. Which means, what is a statutory bail? The statutory bail is granted to an accused if you have served half of the maximum period of jail term. Sir, what about life imprisonment? What is more than half of life imprisonment? We say more than half of the life imprisonment is 10 years. So, long story short, what is a statutory bail? This is statutory bail. Accused is released on bail if you have served more than half of the maximum period of imprisonment. And this is the provision which was introduced in 2005. We clog our jails because we don't have a lot of capacity in our jails. To declog the jails, this provision was introduced so that more and more people can be released on bail. That is what we call statutory bail. Now, you would also know that offenses can be broadly classified into bailable and non bailable. If you are accused of a bailable offense, then you just have to give your surety. Maybe you'll have to give money because bail is, after all, a bond money. And in exchange of that surety, you will be released on bail. But in case of non bailable offenses, it's the discretion of the court. The court will, under its own discretion, decide whether you should be granted bail or not. And this is where we talk about granting bail on the basis of the merits of that case. If you can defend yourself, bail can be granted. If you can prove or you can convince the judges that you are not at flight risk, you will not tamper with the evidence, you will not threaten the witnesses, you can be released on bail. But that is at the discretion of the judges. But in bailable offenses, you have to grant bail to an accused. Further, there is something called default bail. Terms become important. What is an anticipatory bail? For example, I am accused of a crime, but I have not been arrested yet. I will approach the judiciary, I will approach the magistrate that I may be arrested because I'm accused of a particular crime. In anticipation for that arrest, I am asking for bail. That is what we call anticipatory bail before you are arrested. Then there is a statutory bail where an accused is granted bail if you have served half of the maximum sentence. Then there is a default bail. What is a default bail? For example, under CRPC, the police has 60 days to complete the evidence, to complete the investigation, to file the charge sheet. But if the police has failed to complete the investigation and file the charge sheet within this time period, it is unable to complete the investigation, then by default, you will be granted bail. But this 60-day period is relaxed for some special laws. For example, UAPA, for example, Prevention of Money Laundering Act, where it is not necessary for the police or the investigative agencies to complete the investigation within 60 days. So one is default bail, the other is statutory bail. This becomes important for your examination. Okay, great. Let's look at topic number 7, National Human Rights Commission. In the news of late, very important topic. This question has not been asked in the last few years. Who knows? This question can be asked this year. First thing that you have to keep in mind that NHRC is a statutory body. That means a body which is created by the law passed by the parliament. It is not a constitution. And this NHRC was established in 1993 based on the law passed by the parliament, enacted by the parliament, called Protection of Human Rights Act 1993. And this NHRC was created, established, this law was passed because we are conforming to Paris principles. Now, what are these Paris principles? This can also be another important topic. Paris principles were first adopted at the first international workshop on national institutions for the promotion and protection of human rights. This international workshop was held in Paris in 1991. All the institutions throughout the world which are responsible for the protection and promotion of human rights, they met in Paris in 1991 and adopted these Paris principles. And then these Paris principles were also adopted by United Nations General Assembly in 1993. And in response to the adoption of these Paris principles, we in India, the Parliament in India, enacted this Protection of Human Rights Act in 1993, which created National Human Rights Commission, which also created States Human Rights Commission as well. So there is NHRC at the center. There are state human rights commissions in all the states as well. But what are these Paris principles? These Paris principles say that all these national human rights institutions, they should have the broad mandate that you should promote and protect human rights for all, because we have an inalienable human right. That should be the mandate of this institution, which means if we are creating NHRC, the mandate of the NHRC should be very broad, that you should be able to promote and protect human rights for everybody. And you have to ensure that this NHRC is independent of governmental control. The government should not be able to exercise control over NHRC. Why? Because NHRC has to hold governments accountable for violating human rights. Then, if this institution has to hold governments accountable for violating fundamental rights, then this NHRC has to be independent of the governmental control. And this NHRC should also be pluralistic. The membership, the composition of this NHRC should reflect the diversity of that society. Because unless and until this organization, this institution is plural, respecting the pluralism of the society, it may not be able to protect, promote human rights for all. At the same time, this NHRC should have the power of investigation as well. Because if NHRC independently cannot investigate human rights abuses, if NHRC has to be dependent upon the police for investigation, police is under the state control, then investigation would be meaningless. That is why Paris Principle says that there are key principles that every human rights organization in that country will have to follow. You have to be independent of the government. You should have the broad mandate. You should have the investigative powers as well. You should be given enough funding. Because without enough funding, you will not be able to conduct workshops on human rights. You will not be in a position to carry out investigation. You will not be in a position to interact with the civil society. These are the key pillars of Paris Principle. And on the basis of Paris Principle, we have enacted this law which has established national human rights. This law, Protection of the Human Rights Act, was amended in the year 2019. And it was a significant amendment. Why significant amendment? Because previously, the chairperson of the NHRC should have been the former Chief Justice of Supreme Court. Just like for the State Human Rights Commission, the chairperson should have been a retired Chief Justice of a High Court. But in 2019, this law was amended to say now the chairperson of the NHRC should either be the former Chief Justice of India or a former judge of the Supreme Court. The chairperson of the State Human Rights Commission should be either former Chief Justice of a High Court or a former judge of the High Court. That's change number one. Change number two, how can we ensure that this NHRC has the broad mandate to investigate human rights abuses? For that, we should have some experts in NHRC who should have expertise in human rights. Previously, NHRC would have two persons having knowledge of human rights. They were appointed as members. But amendment, when it was done in 2019, it said no, now we will have three members in NHRC who have expertise in human rights. These three members will be appointed, and at least one of this should be a woman. That means at least one of the three members appointed who have specialized knowledge of human rights should be a woman. And then there will be special invitees. Another important potential question for your examination: who are the special invitees to NHRC? If you are a chairperson of National Commission for Scheduled Caste, you are a special invitee to NHRC. Chairperson of the National Commission of Scheduled Tribes, special invitee. National Commission for Backward Classes, special invitee. National Commission for Minorities, special invitee. National Commission for Women, special invitee. Chief Commissioner for the persons with disabilities, you are a special invitee. Special Officer for the National Commission of the Protection of Child Rights. This person will also be the special invitee. So these are the special invitees that you have to keep in. That's the composition of the NHRC. But why NHRC is in the news? Because there is an organization called GAN HRI, Global Alliance of National Human Rights Institutions. So all the countries of the world, more than 120 countries, in these countries, because they have prescribed to Paris principles, they will have national human rights institutions, just like we have NHRC. These 120 countries, they will form and they are members of this global alliance. And now, what this global alliance does, it goes for accreditation. It will look at all these national human rights institutions and see and check and assess whether these national human rights institutions they conform to Paris principles or not. So this global alliance every 5 years will start accrediting these national human rights commissions to see whether they are conforming with Paris principles or not, to see whether NHRC is independent of government and control, whether it reflects pluralism, whether it has the investigative powers, whether it is provided with sufficient funding, whether it is interacting with the civil society. The last time accreditation of our NHRC was done, we were given A status. And an A status would mean that our NHRC will have the power to participate in meetings of United Nations Human Rights Council. We can become a member of this global alliance. We can vote in the meetings of this global alliance as well. So when it was given A status, that means after 5 years, now we have to re-accredit NHRC, reassess NHRC. Now this accreditation is pending for 2 years, 2 to 3 years now. Why? Because Global Alliance and other organizations, for example, Amnesty International, they say that Indian NHRC is not free from governmental control. It does not reflect pluralism. It has become useless in protecting and promoting human rights in India. That is why, for the last 2 to 3 years, Global Alliance has suspended the accreditation of our NHRC. And if our NHRC is given B status, that means we can no longer participate in the meetings of United Nations Human Rights Council. We cannot vote or hold governance positions in this global alliance. That is why this topic becomes important for your examination. Okay, great. Let's look at topic number 8, Right to Information Act and Digital Personal Data Protection Act of 2023. Right to Information, a landmark act which was passed in the year 2005. You would already know the details of this law. Basically, the purpose is, if there is a public authority, if there is a public body, this public authority has to appoint public information officers. And from these public information officers, you can seek information. Seek information related to how the governments take decisions. What sort of money was spent on this particular project? How the money was spent? Basically, RTI is a beautiful tool which has ensured transparency in India. So, if you approach any public authority, this public authority should have a public information officer, and you can approach him with RTI application and seek the information whatever you want. Are political parties also public authorities? This matter went to Central Information Commission, because if a public authority is not giving the information that you're seeking, you can file an appeal before the State Information Commission. If you're still not happy with the answer, that you can approach the Central Information Commission. And ideally, whatever Central Information Commission says, that is final. Although this is where the Supreme Court has also tried to dilute the powers of the CIC, but that would be the subject matter of the mains examination that we don't have to discuss here. CIC said that political parties are also public authorities, which means political parties will also have to appoint these public information officers. And whatever information you can seek, you want to seek from these political parties, you can file the RTA application. CIC said, look at these political parties. Which political parties? The six national political parties. At that time, in 2013, when this judgment was given by CIC, when this ruling was given by CIC, there were six national political parties, and CIC said all these six national political parties, these are public authorities. Why? Because they get tax breaks. They get land at prime location for the construction of their headquarters. Since they get benefit from the state, these are public bodies. These public bodies have to appoint public information officers. But all these political parties, national political parties, they have not abided by the ruling of the CIC. And in fact, the matter is before the Supreme Court as well. But can you seek information from this PIO? And what if it is a personal information? For example, an RTA application was filed by somebody in Tamil Nadu. This RTA application would ask information from this public information officer. asking, tell me the names of the suitable people who are working in the government who are eligible bachelors, so that one amongst them I can possibly marry. Such information cannot be sought because these are personal information. Personal information cannot be sought. For example, your marks card, for example, your caste certificate, for example, your income certificate, for example. If you are not a public, if you're not an IS officer, an IPS officer, because every year you will have to submit your financial details. RTI law, Right to Information Act, says if you are approaching this public information officer and you want private information or personal information, this PIO can withhold that personal information because we are not here to share personal information unless and until sharing this personal information is in the interest of public, is in public interest. Because if it is in public interest, even your personal information should be shared. Otherwise, it would be a violation of privacy, which is a fundamental right under Article 21 of the Constitution. For example, Miss Pooja Khedkar, who faked her caste income certificate, got the OBC non creamy layer certificate, and because of that, she became the IS officer. What if an RTA application is filed seeking her caste certificate? You could have said, no, this is a personal information, we will not share it. But if a larger public interest is involved in sharing this personal information, even then the PIO can say, we will share this personal information. But when Supreme Court in 2017 said in case Puttoswamy case that right to privacy is a fundamental right, the problem was that in India there was no Data Protection Act. How can you protect your personal data? For example, we share our personal data every now and then. I have to do eKYC of my credit card. For that, I have to give my personal information. How this personal information is stored and protected, for that, we needed a law. And that is how in 2023, a law was passed called Digital Personal Data Protection Act. But what is the controversy? This DPTP Act has now amended RTI. Because previously under RTI, you could have sought even the personal information if it was related to public interest. If public interest could be served by revealing this personal information. Now, this added information, public interest has been removed. For example, this Digital Personal Data Protection Act of 2023, what it has done, it has amended the RTI Act of 2005. Information which relates to personal information can be withheld. Ideally, it should have been information which relates to personal information can be withheld except if public interest makes it necessary to reveal this information. This is where critics argue that to this Digital Personal Data Protection Act, the government, the parliament has diluted the Right to Information Act, which was a landmark law in ensuring transparency in India. That is what you need to understand from this topic, the relationship of RTI with the Digital Personal Data Protection Act. Okay? Okay. Let's look at topic number 9, governor's role in assent to bills. This is the case related to Tamil Nadu government versus the Tamil Nadu governor. Let's understand this in great detail. Constitution talks about assent to bills. When a bill is passed by the state legislature and then it is sent to the governor for assent, what are the options available with the governor? Option number one is the governor gives assent. Option number two is the governor withholds assent. Option number three is governor sends the bill back for reconsideration. Except if it is a money bill, because a money bill cannot be sent back by the governor for reconsideration. Third or fourth, the governor can reserve the bill for the consideration of president. When a bill is passed by the state legislature, it is sent to the governor. What are the options available with the governor? The governor may give assent to this bill, then there is no confusion whatsoever, no problem whatsoever, the bill is passed. The governor may withhold assent. Withhold assent means absolute veto. When the governor publicly declares that I'm not going to sign this bill. Previously, we thought that when the governor says I'm going to withhold my assent, I'm not going to sign this bill, that would be the death of the bill. But later, Supreme Court said that you cannot withhold assent and then say the bill is dead. No. When the governor publicly declares that I'm not going to sign this bill, listen to me carefully, very important point. If you have attended my UCAN sessions or daily newspaper analysis that we conduct, then you don't even need to attend this topic again. But if you haven't, then listen to me carefully. Previously, we thought that when the governor publicly declares that I'm not going to sign this bill is dead. It can never become a law. But Supreme Court last year said, no, that does not mean the death of the bill. That means when the governor says, I'm not going to sign this bill, then the same bill, governor has to send to the state legislature again for reconsideration. And if the same bill is passed again, it becomes binding on the governor to sign that bill, to give assent to that bill. That means this is not the third option. This is the second option. First option is sign the bill. Second option is withhold the assent. But once you withhold, then you have to send this bill back to the state legislature for reconsideration. And then the third option is you can reserve the bill for the consideration of the president. All these are considered to be the discretionary powers of the governor. Because constitution does not define what are the discretionary powers of the governor. But something happened in Tamil Nadu, which has been happening in Kerala as well, which has been happening in Telangana as well, which has been happening in Karnataka as well, which has been happening in Punjab as well. The governor is sitting on these bills. Because in how many days, months, the governor has to follow the constitution. It is not mentioned. Time period has not been mentioned in the constitution. And the case in Tamil Nadu was that there were 10 bills on which the governor was not acting. Few bills, the governor had sent the bill back for reconsideration. Even then, he had not signed again. Some bills were sent back to the state legislature for reconsideration. And once the same bills were passed again by the state legislature, now the governor is using option number three, which is now he is reserving the bills for the consideration of the president. Matter went to the Supreme Court. Supreme Court said, enough and enough. We will invoke Article 140. Article 142, which we will discuss in some time, where the Supreme Court can give any order so as to give complete justice, which the Vice President of India, Mr. Dankar, says is like a nuclear missile employed by the Supreme Court on the democratically elected individuals in a democracy. But be that as it may, when this matter reached the court, Supreme Court said all these 10 bills which were pending before the governor or pending before the president all these bills shall be deemed to have been passed. Something remarkable, something extraordinary, something which has never happened in independent India, where without governor's signature, now these 10 bills are laws. And these laws have been notified by the Tamil Nadu government. For the first time ever in the history of independent India, laws have been implemented in Tamil Nadu without the express signature assent of the governor. Remarkable. Because now what the Supreme Court has done, Supreme Court has set a timeline. Timeline is whatever happened in Tamil Nadu, now these bills are passed. From now onwards, governor, what you have to do, there is a time limit that we are prescribing using our power under Article 140. First is, if a bill has been passed by the state legislature, sent to the governor, now the Council of Ministers are advising the governor that don't sign it with the consent of the Chief Minister and the Council of Ministers. They are giving advice to the governor that don't sign this bill. The governor has to act within 1 month and declare that I'm not going to sign. That's the timeline. But what if the Council of Ministers and the Chief Minister advises the governor that you sign on this bill, but governor does not want to sign this bill? This time the governor has 3 months. Within 3 months, you say, I'm not going to sign. Because when you will say within 3 months, I'm not going to sign this bill, then what you have to do? You have to send this bill back to the state legislature. Because just because you said, I'm not going to sign this bill, that does not mean the bill is dead. It can never become a law. Because when you say, I'm not going to sign this bill within 3 months, then you have to send this bill back to the state legislature for reconsideration. And when the same bill is passed again, you have 1 month. And within 1 month, you have no other option but to sign that. And if you want to reserve a bill for the consideration of the president, then also you have 3 months. To reserve these bills for the consideration of the president. Now, this time limit has been prescribed by the Supreme Court, through which it is hoped that this tussle between the elected governments and the governor, this tussle can be resolved. But will this time limit apply to president as well? At the central level, we are not sure, because specifically the court has said with respect to the office of the governor, not the office of the president. Although in Tamil Nadu case, the Supreme Court said those bills which were reserved by the governor for the consideration of the president, and some of these bills president had said, I'm not going to sign, even those bills were declared to have been passed by the parliament, by the president. Okay, great. Then let's look at topic number 10, section 17 capital A in the Prevention of the Corruption Act 1980. Tomorrow, you will qualify this exam and you will become an IAS officer or an IPS officer or a revenue service officer. Let's say you become an IAS officer. And as an IAS officer, you have to perform your duty. As an IAS officer, you have to issue some orders. As an IAS officer, you have to clear files. For example, you have to allot a plot to a marginalized family or to a weaker section of the society for the construction of a house under Pradhan Mantri Awas Yojana. What if the police files a case against you, investigate whether you have done this through corrupt means or through logical means? What will happen to you? You will stop taking decisions. You will stop clearing files, because if you clear this file, you have a threat, a Damocles sword hanging at the top of your head, that the police will investigate you. Although you are not doing corruption, you are just performing your duty. You are just discharging your duty. That is why in the year 2008, Section 17A was inserted into the Prevention of the Corruption Act, which means now if you are an employee of the union government and police wants to file a case against you, inquire or carry out investigation regarding some of the decisions that you have taken, the police cannot inquire without taking the permission of the union government. Union government's permission is necessary. Approval is necessary. Without union government's approval, the police cannot proceed against you if you are discharging your official duty. But if you are an employee of the state government, then state government has to give permission because this is meant to protect you because you're discharging your official duty so that the state government or the union government will have the power to decide whether you have really performed something illogical or not, something corrupt or not. But what about someone else who is neither the employee of the union government nor the employee of the state government, but you are a public servant? And who is this public servant? For example, a minister, for example, a chief minister. Then can you act? Can the police investigate, inquire against a minister or a chief minister? For that, you need the permission of the competent authority. And which is the competent authority? If you're an employee of the state government, state government. Without state government's permission, police cannot inquire against you. If you're an employee of the central government, union government has to give approval, without which the police or the investigative agency cannot inquire or investigate. What about other person? You have to seek the approval of the competent. Which is that competent authority? The authority responsible for removing you. And who is the individual responsible for removing the chief minister or removing a minister? Governor. So if there is an allegation against the chief minister or the minister, the police, if they are discharging their official duties, not if they are murdering somebody or doing some other activities. If you are discharging your official duty and through that official duties discharge, if there is an element of corruption, the police cannot inquire or investigate unless and until you get the permission of the governor. Because governor is the competent authority for this approval. Because governor is the person responsible for removing you from your office. But this does not apply if you have been caught red-handed. That means the police caught you red-handed while accepting a bribe. For that, you don't have to. The police does not have to first take the approval of the competent authority. No, because you have been caught red-handed. And whenever this has happened, whenever you seek the prior approval of the competent authority, then you have to convey your decision within 3, which means this competent authority has to give permission to the police within 3 months or has to say in writing that we need extension for another month, then we will give you the permission or then we will reject the approval. Why is this in the news? Because of a scam called Mudda scam, in which the Karnataka chief minister, Mr. Siddaramaiah, was accused. Mudda stands for Mysuru Urban Development Authority. This is the authority which was responsible or which is responsible for the development and redevelopment of Mysuru, to provide for housing apartments for the citizens in Mysuru, to provide for development in Mysuru region. And the allegation is that there were some properties or some land was illegally acquired by Mudda. So some properties, some land for the development of Mysuru was illegally acquired by Mudda, by Mysuru Urban Development Authority. Then for this illegally acquired property, now Mudda says we will give you compensation. Compensation is in the form of that we will give you some properties which we have constructed on the land which we illegally occupied from yours. And one such person whose land was illegally acquired by Mudda, and for her compensation was to be provided, was the wife of the chief minister, Mr. Siddaramaya. Now, three private individuals approached the Lokayukta in Karnataka that we need to please accept our complaint, please direct the police, investigate the chief minister. But police cannot inquire without the permission of the competent authority, and the competent authority is the governor, and the governor is giving the sanction. Karnataka chief minister approaches the court, Karnataka High Court, on three grounds. Ground number one, my lord, permission of governor is required if the police wants to investigate. Here, police does not want to investigate. Here, it is the three private persons who are approaching the Lokayukta on the basis of the complaint by the private persons. Governor should not give approval for investigation. Second, I was not the chief minister when this land was illegally acquired by Mudda or when compensation was decided by Mudda for my wife. So, how was this decision taken by me in my professional capacity as the chief minister, as a public body, as a public servant? Third, governor was given an advice by the cabinet of Karnataka, don't give approval to the Lokayukta. Don't give permission to the Lokayukta to carry the investigation because our advice on the chief minister is on the governor is binding. When matter went to the Karnataka High Court rejected all these three grounds raised by the Karnataka government. What are the grounds? Number one, the Karnataka High Court said this time it is the discretion of the governor. The governor is not bound on the aid and advice of the chief minister and council of ministers. Why? Because there is a conflict of interest. The minister is appointed as a minister only on the recommendations of the chief minister. So how can minister advise the governor if it is against the chief minister? Because your ministryship is dependent upon the chief minister. Since there is conflict of interest, in this case, the advice of the cabinet is not binding on the governor. Governor did right in granting sanction. Number one. Number two, the court said, yes, police needs approval of the competent authority before carrying out investigation. This is meant to protect this public servant. If this does not apply to three private individuals, then what these three private individuals had to do, they had to approach the police. And the police had to necessarily file the FIR. So, how can you protect these public servants? Sir, what are you saying? This is confusing. Let me make it simple for you. You are an officer and you are performing some duty. For the discharge of your public duty, police cannot investigate you without the approval of the competent authority. Why is that the case? Because we want to protect you. Now, the police does not want to investigate. Private persons, they want police to investigate. So, police does not want approval of the competent authority. Private persons want. The government of Karnataka said, when police is not wanting to investigate, why on the basis of the complaint by the private persons is the governor giving approval? The court said, if we will not give approval on the basis of the private individuals, then what is the option? Private persons will approach the police. Police has to necessarily file FIR. Then where is the protection for these public servants? That is why even private individuals, when they file a complaint, the police cannot investigate unless and until approval of the competent authorities. And third, Mr. Siddaramaya, You were the leader of the ruling political party when this decision was taken. It was during your time that enhanced compensation was provided to those whose lands have been illegally acquired by Mudda. At least in these circumstances, it merits investigation. So, what you need to know from the examination or the prelims examination is Section 17, capital A of the Prevention of the Corruption Act. You need to know these provisions where if you are a state government employee, state government becomes the competent authority. Union employee, union government becomes the competent authority. Or for another person, the competent authority would be the authority which is competent to remove you from your office, which in case of ministers and chief minister becomes the governor. Clear? And in this case, the advice of the chief minister or the cabinet is not binding on the government. Okay? Great. Let's look at topic 11, section 6, capital A of the Citizenship Act. Article 11 of the Constitution gives power to the parliament. That parliament, what you can do, you can enact a law, and through this law, you can regulate all matters related to citizenship. All matters related to citizenship. Right or wrong? Right. For example, in my Bare Act lectures, we have discussed Articles 5 to 11. And basically, the purpose is I don't want to repeat all of them here again. Article 5 to 10, they basically talk about citizenship at the time of the commencement of the Constitution. That means when the Constitution was commenced, at that time, who is the citizen of India? Who can become the citizen of India? Who cannot become the citizen of India? Who can register to become the citizen of India? That is provided under Articles 5 to 10. But Article 11 gives unfractured power to the parliament that you can, by enacting a law, regulate all matters related. And that is how Citizenship Act was passed in the year 1955. And it is this law which talks about what are the ways by which you can acquire Indian citizenship: by birth, by registration, by descent, by incorporation of a foreign territory, by naturalization. This is the law which tells us that there are three ways by which you can lose your citizenship, which is by renunciation, which is by deprivation, which is by termination. Those are the things that you should revise. But very briefly, there is a cutoff date for citizenship that you should have entered India on or before 19th of July 19. If you have entered India before that date, or if you are eligible to become the citizen of India on 19th of July 1948, you are the citizen. Otherwise, you are not. But something happened in Assam, and there was a massive movement against illegal migration. And this is how Assam agitation started in 1979, where the people of Assam felt that there is illegal migration into Assam from Bengal, from Bangladesh. And these illegal migrants, they are changing the demography of our state, changing the culture of our state, assaulting our language as well. And this movement, this agitation lasted till 1985, where finally Assam Accord was between the government of Assam, the government of India, Rajiv Gandhi was the prime minister, and the protesters led by All Assam Students Union, ASU. Now, according to this Assam Accord, what happened? This Assam Accord said all those who have entered Assam before 1st of January 1960, you are the citizen. But if you have entered Assam between 1st January 1966 till 25th March 1971, you are removed from the electoral roll. That means for 10 years, you cannot contest elections. For 10 years, you cannot vote in the Indian elections. Only after the 10-year period is over, then you can register as the citizens. But those who have entered after 25th March 1971, those are to be identified, arrested, and deported. Why 25th March 1971? Because this is the time when Operation Searchlight was launched by Pakistani army. This was what led to massive exodus of Bangladeshis into India. This was at the peak of the India Pakistan war, which ultimately led to the emergence of Bangladesh as an independent entity. But long story short, to implement this Assam Accord, Section 6 capital A was inserted into the Citizenship Act. Now there is a different cutoff date for those who are to be the residents of Assam. That means those who have entered India from the Pakistan side, from the West Pakistan side, their cutoff date is 19th of July 1948. And those who have entered the eastern side, from the eastern side to India, their cutoff date is 1971, 25th March 1971. Can there be two different cutoff dates for becoming the citizens of India? That was the challenge before the Supreme Court when the Supreme Court was hearing petitions challenging the constitutional validity of Section 6 capital A of the Citizenship Act. And the Supreme Court said that this Section 6 capital A is constitutional because it is not violative of Article 14. Because the petitioners challenged that prescribing different cutoff date for becoming citizens is arbitrary. And right against arbitrariness is a fundamental right under Article 14 of the Constitution. But Supreme Court did not agree and said Section 6 capital A is constitutional. Why? Because this Section 6 capital A was the intent of the legislature to give effect to the Assam Accord. Now listen to me carefully. Article 6 of the Constitution talks about this cutoff date, 19 July 1940. If this Article 6 was to be amended, that would have required a constitutional amendment. But Article 11 of the Constitution gives power to the Parliament to regulate all matters related to citizenship. And that's how Citizenship Act of 1955 was passed. So this is primarily an ordinary law. Sir, what are you trying to say? Can an ordinary law violate fundamental rights? No, it can't. But the fact is, Article 11 says power is given to the Parliament. You can regulate all matters related to. Article 10 of the Constitution talks about continuance of the rights of the citizenship. That means if you were granted citizenship under Article 5, Article 6, Article 7 of the Indian Constitution, you will continue to remain the citizens of India subject to a law passed by the Parliament under Article 11. Basically, under Article 11, when Parliament will enact a law regulating citizenship, it can do anything. That is how it has prescribed a different cutoff date for citizens. Such it is not. So what is Section 6 capital A? That is related to the implementation of the Assam Accord, which was because of the Assam agitation between 1979 to 1985, which has prescribed a different cutoff date to become the citizen of India if you have migrated from the eastern part. And some of you would get confused with clause 6 of the Assam Accord. So keep three things in mind. There is Article 6 of Indian Constitution, which talks about the cutoff date, 19 July 1940. Then there is Section 6 capital A of the Citizenship Act, which talks about a different cutoff date to become the citizen of India in Assam. For that, you also need to understand that National Register of Citizens was updated only for Assam, because National Register of Citizens was first updated in 1951, but it was updated only for Assam in 2009, 1819. And then third is the clause 6 of the Assam Accord. What is that clause 6? Clause 6 says that some constitutional, legislative, administrative safeguards shall be provided to preserve, protect, and promote cultural, social, linguistic identity and heritage of the Assamese. That means who are now the original inhabitants of Assam? Those who were there right from the Ahom dynasty. Those who are part of the NRC of 1951 as well. For them, sufficient safeguard should be provided. Constitutional, legislative, administrative safeguard should be provided for those who are the original inhabitants of Assam. There are others who have become citizens of India because they got entry into Assam after 66, before 1971. But those are not the original inhabitants of Assam. Those are not the SMEs, original SMEs people. The original SMEs people, for them, there are special safeguards that can be implemented under clause 6 of the Assam Accord. That's what you have to understand. Then in case of Assam, which cutoff date will prevail? Section 6A date or 31st December 2014? Good question, because now CAA 2019 has prescribed another date. And that date is if you have entered India on or before December 31, 2014, you are not to be deemed as illegal migrants, because illegal migrants are not eligible for citizenship. So those who have entered India from Pakistan, Afghanistan, Bangladesh, belonging to the six religious minorities of these three countries, Hindus, Christians, Buddhists, Jains, Sikhs, Parsis. If you have entered India on or before December 31, 2014, you are not deemed as illegal migrants. When you are not deemed as illegal migrants, which means you are a legal migrant and as such eligible for citizenship through naturalization. Yeah? And for that, you also need to understand the CAA will not apply to the tribal areas of Assam. To the tribal areas of Assam, Meghalaya, Mizoram, Tripura will also not apply to those where inner line permit is employed. For example, Manipur, Nagaland, Arunachal Pradesh, which means in Assam, CAA will be implemented in the entire state except the three tribal districts which get protection under Schedule 6 of the Constitution. Clear? Great. So at this point, we will take a break of 15 minutes. We will come back at 10:20 and discuss the remaining provisions, remaining topics that we have to cover today. So as of now, we have covered 11 topics. There are a lot of topics left. We'll take a break of 15 minutes and resume at 10:20. See you on the other side of the break.
Welcome back, and let's look at this question on your screen. Which of the following statements is or are correct? Let me know what is the right answer. The Handbook on the Working of Ministry of Parliamentary Affairs explains the appointment and swearing in of Speaker pro tem. Is it correct? The Prime Minister has no role in the appointment of a Speaker pro tem. Is it correct or incorrect? Incorrect. The Speaker pro tem is barred from contesting election to the post of a Speaker of the Lok Sabha. Is this correct or incorrect? Select the correct code from below. A, only one is the right answer. Now let's understand the office of the Speaker pro tem in detail. It was in news, a lot of controversy as well. Let's try and understand. Article 94 of the Constitution says first there has to be the Speaker. Constitution says as soon as possible the House of Lok Sabha shall elect two of its members, one as the Speaker, the other as the Deputy Speaker. Both are constitutional positions, and this word shall makes it mandatory that we should have Speaker as well as Deputy Speaker. But then the Constitution further says the House of Lok Sabha shall, as soon as may be, elect two of its members, one as the Speaker and the other as Deputy Speaker. This as soon as may be means that there is no time period, time limit mentioned in the Constitution. That is why 17th Lok Sabha, the last Lok Sabha, was the first one where we did not have a Deputy Speaker. And the current 18th Lok Sabha also, we do not have a Deputy Speaker. Why? I don't know the reason. Maybe because by convention, although not mentioned in the Constitution, but by convention, the office of the Speaker is occupied by the member of the ruling political party or the ruling coalition, and the office of the Deputy Speaker is occupied by the member of the opposition, by somebody who is from the opposition. But Constitution says under Article 94 that when the Lok Sabha is dissolved, all other MPs of Lok Sabha, their term is also over, their term is also expired, but one person does not resign, and that person is the Speaker. And when does Speaker resign? When the new Lok Sabha is meeting for the first time. So if the new Lok Sabha is meeting for the first time today in the morning, the Speaker of the previous Lok Sabha will resign. But then who will administer oath to newly elected MPs of the Lok Sabha? The oath is administered by the President or somebody who is appointed by the President. And that person is Speaker pro tem. But who is the Speaker pro tem going to be? That's not mentioned in the Constitution. That's not mentioned in the rules. That is mentioned in the Parliamentary Affairs Ministries Handbook. And according to this handbook, what happens? When the government is formed, which means when the Prime Minister is administered oath of office and secrecy, and then along with the Prime Minister, other ministers are also administered oath of office and secrecy, which means now we have Minister for Parliamentary Affairs. We have the Ministry of Parliamentary Affairs. In this Ministry of Parliamentary Affairs, we have a division called Legislative Wing. And what this Legislative Wing will do, it will look at all these 543 MPs and start ranking them. Ranking them in what order? In terms of their experience. Experience means for how many terms have these MPs been the member of the Lok Sabha? Previously, we would take experience in terms of their membership of both Lok Sabha as well as Rajya Sabha. So if you have been a member of the Lok Sabha for 5 terms, member of the Rajya Sabha for 5 terms,
You are the senior most member. You could be appointed as Speaker Pro Tem. And what is your job? Your jobs, there are two roles for you. One is to administer oath to newly elected MPs, and the second is to preside over the election of the Speaker, because we need to elect the Speaker. Now, what we are doing is we are ranking the MPs in terms of their experience, in terms of their term in Lok Sabha only. That means whoever has been the senior most MP of the Lok Sabha, we rank them according to their experience. But whether this experience is going to be uninterrupted, for example, I am an MP who has been the MP of the Lok Sabha for 8 terms. There is another MP who has been the MP of the Lok Sabha for 7 terms. But this MP has been continuously, for 7 terms, continuously the member of the Lok Sabha. And this MP has been the MP of the Lok Sabha initially for 5 terms, then there was a break, then 3 more terms. So, who is the senior most MP? That's for the president to decide. That's for the government to decide. So, when the Ministry of Parliamentary Affairs, its legislative wing, will start ranking these MPs in terms of their experience, they will take experience only in Lok Sabha into consideration, and it should be uninterrupted as well. And accordingly, the senior most member will be nominated by the president as the speaker. Prime Minister has a role. So, this legislative wing, when it will present this list to the government, to the Minister of Parliamentary Affairs, and the Prime Minister will select somebody and will recommend this person to the president that please appoint this person as the Speaker pro tem. That is why this time also, although Mr. Suresh, who is the MP of Lok Sabha from Congress, he was an 8-term member of the Lok Sabha, but he was overlooked. And another MP of BJP from Odisha was appointed as the Speaker pro tem, although his term was only for 7 terms. But the government defended this appointment, saying the term of this BJP MP was 7 terms continuously, uninterrupted. And the term of Mr. Suresh was not uninterrupted. That is why we recommended this MP from Odisha as the Speaker pro tem. This Speaker pro tem is administered oath by the President herself. So if the new Lok Sabha is meeting today, let's say the new Lok Sabha is meeting at 11 o'clock in the morning, maybe at the time which is convenient for the president, which can be 9:30, which can be 10, president will administer oath to the Speaker pro tem. And then the Speaker pro tem will administer oath to all the newly elected MPs. But this Speaker pro tem is assisted by other MPs as well, other senior MPs as well. Previously, the president would appoint Speaker pro tem, and the government would also say that to assist Speaker pro tem, we have 3 other senior MPs. But these 3 senior MPs will be administered oath by Speaker pro tem. So, president will administer oath only to Speaker pro tem. Speaker pro tem will administer oath to these 3 other MPs who will assist the Speaker pro tem. But this time, 5 other MPs were also appointed to this panel. That means, apart from Speaker pro tem, 5 other MPs were also selected. That means these 5 MPs will assist the Speaker pro tem in administering oath to newly elected MPs. Where is it mentioned? It is mentioned in the handbook of the Ministry of Parliamentary Affairs, not mentioned in the Constitution. But can the same person who is appointed as Speaker pro tem also contest election to the post of the Speaker? This has happened. This has happened when? When Mr. Somnath Chatterjee was appointed as the Speaker pro tem, but he also wanted to contest election to the post of the Speaker. And at that time, in 2004, 2 Speaker pro tem were appointed. So, is it necessary that we should have only 1 Speaker pro tem? No. We have had instances in the past where 2 Speaker pro tems were appointed because one of them later on contested election to the post of the Speaker. Because once you are contesting election to the post of the Speaker, you should not be presiding over Lok Sabha. These facts are very important, can be relevant for your prelims examination. Clear? Let's look at topic number 13, Delimitation Commission. Hot topic, very much in the news. In fact, last year also the question was asked, how many delimitation commissions have been established, set up till December 2023? How many delimitation commissions have been set up? For 1952, 1963, 1973, and 2002. Do you want me to explain the entire process of delimitation, or you have covered this in the live classes, or you can, or previous Hindu newspaper analysis sessions? Covered. Very good. Okay. Now the point is, few facts important for prelims. Who has been given the power to carry out delimitation in India? Is it only Delimitation Commission which has the authority to carry out delimitation exercise in India? No. It can also be done by the Election Commission of India. So one important thing, four times delimitation commissions have been set up. Second, it is not only delimitation commission, any other authority, for example, Election Commission of India can be entrusted with the delimitation of constituencies. For example, in case of Jammu and Kashmir, delimitation commission was set up. But in case of Assam, Election Commission of India carried out delimitation exercise. But we also know that there is Article 329 of the Constitution, which says that the award of the Delimitation Commission cannot be challenged in any court of law. But for that, we have a historic judgment of 2024 in Kishore Chandra Rathore versus Union of India, where Supreme Court has said that even this award of the Delimitation Commission can be challenged in the court, can be judicially reviewed on the grounds of if this order is manifestly arbitrary. Because if it is arbitrary, it would violate Article 14 of the Constitution. Why this case went to the court? Because there was a seat in Gujarat Legislative Assembly which was reserved for STs. Then, when the delimitation exercise was carried out in 2002, the final award was given in 2008. This seat was reserved for SCs, despite the fact that the population of this constituency was dominated by STs. This is where the petitioner approached the Gujarat High Court. Gujarat High Court said, we can't help you because the award of the Delimitation Commission cannot be challenged in any court of law under Article 329. Then the petitioner approached the Supreme Court. Supreme Court said, we can review this order if it is manifestly arbitrary, if it is violative of the constitutional values. On this ground, we can challenge it. On this ground, we can review it. That's where it becomes important. But when Delimitation Commission is set up, who all are part of this delimitation? Delimitation Commission is headed by a person who is or has been a judge of the Supreme Court. That means it is not necessary that a retired judge of the Supreme Court should be the chairperson of this Delimitation Commission. It can also have a serving judge of the Supreme Court as the chairperson of the Delimitation Commission. For example, in case of Jammu and Kashmir, Justice Ranjana Desai, a former judge of the Supreme Court, was the chairperson of the Delimitation. This person is appointed by the central government. Who are the other members? The Chief Election Commissioner will be the ex officio member. It's not necessary that another member should be the CEC. It can be another election commissioner nominated by the Chief Election Commissioner, but ex officio member. And if this delimitation is to be carried out in Assam, then the Chief Electoral Officer of Assam will also be a member. So, Delimitation Commission consists of a chairperson who is or has been the judge of the Supreme Court appointed by the central government, CEC or the election commissioner nominated by the chief election commissioner as the ex officio member, and a chief electoral officer of that state. Then there are associate members as well. Who are the associate members? For example, if Delimitation Commission is set up for Assam, apart from chairperson, and two members, one CEC or EC and the other chief electoral officer. We can also have associate members. Although these associate members do not have voting rights, they are there just to present their viewpoint before the commission. They're there just to give their inputs to the commission. They don't have voting rights. Voting rights are with this commission, but they will have associate members. Who are these associate members? 10 persons. Five will be the MPs of Lok Sabha from that state. Five will be the MLAs from that state. MPs from Lok Sabha will be nominated by the Speaker. MLAs from the Legislative Assembly will be nominated by the Speaker. But, sir, I have a question. What? What if delimitation is carried out in a state where the number of MPs in Lok Sabha are less than five or they are five? In that case, all such members are associate members, which means in case of Jammu and Kashmir, if 10 associate members are to be appointed, there was no Jammu and Kashmir Legislative Assembly. That means there will be only associate members and five associate members. In that case, all the five MPs of Jammu and Kashmir in Lok Sabha, they became the MP, they became the associate member. Which means if in a state where the number of MPs in Lok Sabha are five or less, then all such members will be part of the delimitation commission as the associate members, but they don't have the voting rights because voting rights are with the delimitation. Clear? Further, what you need to understand is that since delimitation is to be carried out after the census, there are two things that you have to keep in mind. Mostly they are overlooked or misunderstood by the aspirant. One is 42nd Constitutional Amendment Act of 1976. It froze delimitation till 2001 for 25 years. Then 84th Constitutional Amendment Act froze delimitation till the census after 2020. But sir, this is already covered in the newspapers. What is it that you want to stress upon? When Constitution was amended in 1976 to freeze delimitation for 25 years, no reason was given. Why we are stopping it, no reason was given. The reason that we are stopping it for another 25 years because of population control, to stabilize population, because of our national population policy. This was communicated, this was told only in 2001 when 84th Constitutional Amendment Act was passed. That is something that you have to keep in mind. These are the two things that you have to keep in mind. 42nd Amendment froze till 2001. 84th Amendment froze till the census after 2020. Clear? But this time a reason was given that it is because we want to stabilize population. This time no reason was given, but it was understood that we are doing this to stabilize population, to control population in this country. Okay, great. Let's look at contempt of court. First up, contempt of Supreme Court. If there is a law to be passed to regulate contempt of court in India for the Supreme Court, that power is available with the Parliament. Parliament alone can pass that law. But what if there is contempt of High Court? A law regulating the contempt of High Court can be passed by the state legislature as well. This differentiation becomes important. And we have a parliamentary law passed in the year 1971, which talks about the Contempt of Court Act. And it is this Contempt of Court Act which talks about two types of contempt: civil contempt and criminal contempt. In fact, this was one of the questions asked in your prelims examination previously. The Constitution defines or classifies contempt into civil and criminal. That's not something which is done by the Constitution. That is something done by the law enacted by the Parliament in 1970. Clear? That's number one. Number two, this criminal contempt case, if it is to be filed, how can you approach the court? One is if the court takes up this matter suo motu on its own. There is a tweet, there is an article, there is something being said, and the court gets to know about this and deems that this is contemptuous. Court on its own can take up this matter and decide whether contempt of court proceedings can be initiated against that person. Or Attorney General for India at the central level or the Solicitor General of India at the central level can approach the court. Or any third person means if it is not the Supreme Court judge himself or herself, if it is not the Attorney General or the Solicitor General themselves, then any third person can approach the court, but that too only with the written permission of Attorney and Solicitor General. That means if you want to file a contempt of court case against me, if I've said something against the Supreme Court in this lecture, either Supreme Court on its own can take up this matter, or Attorney General or Solicitor General will have to approach the Supreme Court, or you can approach the Supreme Court, but only after getting the written permission of the Attorney General. Why this written permission is required? This can be asked in your examination to save the time of the court. Otherwise, any Tom, Dick, and Harry can approach the court and waste the time of the court by filing these petitions. Whether these petitions have some merit or not, whether they are indeed contemptuous or not, you need written permission of the attorney or the solicitor general. At the state level, you need the permission of the advocate general of the state or a high court. And in India, Supreme Court can punish people for its contempt. High courts can also punish people for its contempt, but district court judges cannot punish people for contempt. This power is not given to the district court. But that does not mean you can commit contempt of the district court. If you have done that, then High Court will punish you on behalf of the Supreme Court, on behalf of the district court for committing contempt of the district court. Facts become important for you. Clear? Let's look at the question. And let me know in the comment section what is the right answer. The Supreme Court cannot take an action against anyone in a criminal contempt matter without the written consent of the Attorney General or the Solicitor General. The Supreme Court can. If the Supreme Court takes the matter suo motu on its own, a case of criminal contempt shall be heard and determined by a bench of not less than two judges. This is correct. Minimum, we can have two judges hearing the contempt case. No court shall initiate any proceedings of contempt after the expiry of period of 1 year from the date on which the contempt is alleged to have been committed. If the lecture is taken today, then within a year you have to approach the court. Once 1 year is over, once the prelims 2026 exam has been conducted, then you cannot approach the court. So 1 year has to, 1 year is the limitation. Which of these statements are correct? B, two statements is the correct answer. Done? Very good. Topic 15, Article 142. What is this Article 142? Only the power of the Supreme Court. Is this power given to the high courts? No. This is the power only available with the Supreme Court. And what is this power? Through this power, we say this power is plenary in character. Plenary in character means Unrestricted by executive. Executive cannot dictate the Supreme Court how to exercise this power. Plenary in character. And under Article 142, Supreme Court alone can give any order so as to give complete justice. Complete justice when no other option is there. For example, in case of a student belonging to the Dalit community who failed to submit 17,000 fee because he got admission at an IIT, he failed to submit the fee on time, then what is the remedy available? Nothing. Has the IIT done a disservice to you by not admitting you? No. You cleared the exam, you had to pay the fee, you did not pay the fee on time. We can't help you because there's a limit. Otherwise, you could have come after 2 months as well, saying, I failed to submit the fee on time. Now give me the admission. We have to close the admission at some point. No other remedy is available. This Dalit boy approached the High Court. High Court said, we can't help you, but you can go to the Supreme Court. Supreme Court said, now there is no other remedy available, but we have to give complete justice in this case. The Supreme Court directed the IIT that now you admit him into your college after taking the fee. Complete justice. Similarly, if 10 bills were reserved, were not assented to by the governor of Tamil Nadu, some of these bills were reserved for the consideration of the president, no action was taken. What is the other remedy available? Nothing. The other remedy could have been very important. This is something that I missed. Mandamus. Normally, the jurisprudence is that you can't approach the Supreme Court with a writ of mandamus to direct the president to do something or to direct the governor to do something. No. You can approach the Supreme Court with the writ petition of mandamus if a public body has failed to discharge its duty, has failed to perform its duty, but you can't file a writ petition of mandamus against the president or the governor. But in Tamil Nadu case, Supreme Court said we may consider issuing a writ of mandamus to the governor that you act and sign these bills. That's remarkable. That's something that you have to keep. One option for the Supreme Court was that it could have directed the governor, you sign these bills, which you had reserved for the consideration of the, or which you are not signing. We direct you, we command you, you sign these bills. This was one option, which the Supreme Court said we can consider. The other option was when there is no other remedy available, consider that these bills are passed under Article 140 by issuing the order under Article 1 to give complete justice. Let's look at the question and tell me what in the comment section what is the right answer. Which of the following statements regarding Article 142 is or are correct? Number one, the Supreme Court may pass such order as is necessary for doing complete justice in any cause or matter pending before it. The Supreme Court has the power to make any order for the purpose of investigation or punishment of any contempt of itself. Select the correct quote from below. CCAAD. D. Bottle. Okay. It is not only about giving any order so as to give complete justice. The Supreme Court can use Article 142 to issue any order so as to receive documents, so as to issue an order for the investigation and punishment for contempt of itself. That's also mentioned under the clause of Article 142. So both these statements are correct. C is the right answer. Let's look at topic 16, curative petitions. The judgment has been given by the Supreme Court and you are not happy with the judgment. You are still aggrieved. What is the option? the option available is you have to file or you can file a review petition. What are the grounds? Review petition is accepted or rejected on two grounds. If an error has been pointed out, number two, if new facts have been discovered. A judgment has been given by the Supreme Court. For example, Supreme Court gave the judgment. 9 judges of the Supreme Court, by the majority of 8:1, said states have the right to impose cess on royalty. States have the right to impose tax on lands bearing minerals. This judgment was not acceptable to the central government. Central government approached the Supreme Court asking for the review of that judgment. But this review petition was rejected by the Supreme Court. Why? Because the Supreme Court said, you have not pointed out any error in our judgment, and no new facts have been discovered in this case which might tilt the balance in favor of the central government. So we are dismissing this review petition. But this review petition must be filed within 30 days of the court judgment. And this review petition will be heard by the same judges as much as possible. Now, if the judge is dead or the judge has retired, now we can't bring that person back from death and tell him or her that you have to hear this review petition. No, as much as possible, same judges. But composition has to remain the same. It was a 5 judge bench who gave this judgment. Even if 2 judges have retired or are dead, 2 other judges, senior judges, will have to be asked to review this review petition. Even if this review petition is dismissed, there was no option. Article 137 of 36, 37 of the Constitution would say this case is over. Then in the year 2000, in a landmark case known as Hurra versus Hurra, Rupa Ashok Hurra versus Ashok Hurra, it was basically a matrimonial case, but Supreme Court said finality of justice is important, but it cannot be at the cost of the justice. So even after the review petition is dismissed, you can file another review petition, and that another review petition is known as the curative petition. But this curative petition will have to be filed within a reasonable time period. That means there is no time limit. For review petition, it is 30 days. For curative petition, it is within reasonable time period. It has to be heard by same judges who dismissed your review petition, plus 3 senior most judges of the Supreme Court. But the grounds on which this curative petition is accepted, very strict. The grounds on the basis of which your review petition is accepted is if you have pointed out an error, if new facts have been discovered. But in case of curative petition, the grounds are if you have been adversely affected by this judgment, if principles of natural justice has been violated, if you are pointing towards a bias in the mind of a judge, because of that biasness, he has dismissed my review petition. On these very narrow grounds, your curative petition, the success rate of curative petition is 0.01%, which means majority of the curative petitions are dismissed. Done? This is curative petition. And why this curative petition becomes important? Because this curative petition was filed in case of Delhi Metro. It was filed in case of Union Carbide. For example, when the Bhopal gas tragedy took place, then compensation was awarded by the court. Then central government filed a curative petition asking the court that you should enhance the compensation provided to the victims. This was dismissed. But these petitions became very, very popular, very, very much in the news. That is why it becomes important. And then let's look at the question. With reference to the curative petitions, consider the following statements. A curative petition can be filed only after the dismissal of a review petition. The right to file a curative petition is explicitly mentioned in Article 137. The concept of curative petition was evolved by the Supreme Court in exercise of its inherent powers under Article 142. A curative petition is heard by the same bench of judges that passed the original judgment. Which of these statements given above is or are correct? Let me know what is the right answer. A curative petition can be filed only after the dismissal of a review petition by the Supreme Court. This is correct. The right to file a curative petition is explicitly mentioned in Article 137. It's not mentioned, it has evolved because of the Hurrah versus Hurrah judgment. And at that time, in Hurrah versus Hurrah judgment, Supreme Court invoked this power using Article 142. Supreme Court said finality of justice is important, but it cannot be at the cost of the justice. So as to give complete justice, you can file another review petition called curative petition. A curative petition is heard by the same bench of judges that passed the original judgment. No, plus three senior most judges. So what is the right answer? A, 1 and 3 is the right answer. Let's look at topic 17, Form 17A, Form 17C. In fact, petitions were filed in the court. Petition was filed by Association for Democratic Reform, a non-governmental organization which is working in the field of electoral reforms. Petition number 1 was we should revert to ballot papers. Second plea was there should be 100% VVPAT verification. Third was that Form 17C should be kept in public domain. Supreme Court said we can't set the ball back, we can't turn the clock back, we can't go back to the ballot papers. EVMs are foolproof. On 100% VVPAT verification, Supreme Court said no, but we will verify 5 EVMs per assembly constituency in a parliamentary constituency. Because there's a parliamentary constituency, it has many assembly constituencies, then 5 VVPATs will be verified per assembly constituency in a parliamentary constituency. But if a candidate who has won, and then there is a candidate at serial number 2 and 3, if they want, they can approach and they may call for 5% VVPAT verification. And then 5% VVPATs will be verified. Right now, it is 5 VVPATs per assembly constituency in a parliamentary. That's it. But if you have lost the election, you have come at serial number 2 or serial number 3, you can ask for 5% process. You have to bear that money. But if it is found that this verification has been found not foolproof, there is some error, VVPAT and EVMs, they are not matching, then we will reimburse that money. On Form 17A and 17C, what is the difference? You are a voter. Your name is mentioned on the electoral rolls. You are assigned to a polling booth. When you approach the polling booth, at the entrance, you fill a form known as Form 17A. Form 17A is like what is displayed on your screen. There is the serial number of the elector in the electoral roll. What is your name? What are the documents that you have submitted as proof that you have been assigned to this polling booth? For example, you are giving an electoral photo identity card. You have to give your signature or thumb impression. That means through Form 17A, we will get to know how many people entered the polling booth. That's it. But the real picture of how many voted is captured under Form 17, because Form 17C will now say how many voted inside the polling booth. Not only how many entered, how many voted, how many were not allowed to vote, how many refused to vote. The full picture of total voter turnout in that polling booth will be captured by Form 17. Now, you tell me, is this Form 17C shared with anybody? It is. It is shared with candidate. It is shared with the polling agent of that candidate. But it is not displayed on the Election Commission of India website. It is not visible to the public. Petition was filed in the court that you should keep it public. And now Election Commission of India has said we will meet political parties to see whether we can keep it public, because as of now, we have no legal mandate to make it public. The only legal mandate is we will give it to the election candidate or the polling agent of that candidate. Why it was in the news? Because you would know that there was some discrepancy. Basically, it is this Form 17C which will tell us about the voter turnout. And at 8 o'clock, if the Election Commission of India said that the voting percentage was 61, few days later, Election Commission of India would say, no, the voting percentage is 66. Opposition parties alleged that you show us 17C because maybe after the polling has ended, you have allowed people to vote. Whatever it is, whether those criticisms are genuine or bona fide or immaterial, useless, that we don't have to get into. We just need to understand what is Form 17A, how is it different from Form 17C. Form 17C captures the total voter turnout. Form 17A only captures the number of people who have been assigned to a polling booth who have entered the polling booth. Clear? Election Commission of India has also now said that these electors' photo identity card will have to be linked with Aadhaar. Why? Because once it is linked with Aadhaar, we can remove the duplicates as well, because Aadhaar is unique. EPIC is not unique. And what makes Aadhaar unique is because of biometrics, iris, fingerprints, biometrics that are shared. As of now, the position is if EPIC is to be linked with Aadhaar, you can either say, yes, this is my Aadhaar number, link it, or you can say, no, because I do not have the Aadhaar. So right now, there are two options. One, you give your Aadhaar, link it with EPIC. You don't give your Aadhaar because you don't have. Now the government is considering that we change the election conduct rule and say, even if you have Aadhaar, but you don't want to share it, and why you don't want to share it, give reasons. Give reasons why you don't want to share the Aadhaar number for linking your Aadhaar with the elector's photo. We have discussed this previously. For this EPIC Aadhaar linkage to work, there has to be 100%, otherwise, no. Done? Let's quickly look at topic 18, Niti Aayog. And why Niti Aayog is in the news? I'm expecting a question on Niti Aayog because this is the 10th anniversary of Niti Aayog. Niti Aayog replaced the erstwhile Planning Commission. And from 1st of January 2015, we have this Niti Aayog, which is considered to be the prominent think tank of the government. Is this Niti Aayog a constitutional body? No. Is it a statutory body? No. It is a non constitutional or extra constitutional, non statutory body. What are the facts related to Niti Aayog? Niti Aayog is supported by three entities. One is it has an attached office called DMEO, Development Monitoring and Evaluation Organization. Second, it has a flagship initiative called Atal Innovation Mission. Third, there is an autonomous body which is attached to this Niti Aayog, which is under Niti Aayog, and that is National Institute of Labor Economics Research and Development. These three things you have to keep in mind. These three entities you have to keep in mind. Flagship initiative, Atal Innovation Mission, National Institute of Labor Economics Research and Development, which is an autonomous body under Niti Aayog, and Niti Aayog has an attached office called Development Monitoring and Evaluation. What is the current composition of Niti? Look at the screen. And this is of 16th of July 2024, the most recent one. Niti Aayog is headed by, by the Prime Minister, who is the chairman of the Niti Aayog. It has a vice chairperson who is appointed by the Prime Minister, Mr. Berry. Then it has full time members. How many? Four full time members. Then it has ex officio members. Who are these ex officio members? Four ministers nominated by the Prime Minister. How many? Four. So, four full time members, four ex officio members. But then there are some special invitees. You don't have to remember these names, but you just have to keep in mind that there are some invitees as well. There are ex officio members, full time members, chairperson, vice chairperson. And this Niti Aayog, as I said, it is headed by the Prime Minister, but it is considered to be a federal body because its governing council consists of chief ministers of all the states and the administrators of union territories as well. Sir, what about Delhi, Puducherry, and Jammu and Kashmir? Will their chief ministers or their lieutenant governors be part of Niti Aayog? Their chief ministers will be part. But what about five other UTs where we have administrator, where they do not have a chief minister? Then their administrators will be part of this governing council. And then regional councils may also be formed to address specific issues concerning one state or the region of that state. So, regional councils, governing council, experts, for example, full time experts, four. Similarly, ex officio chairperson, ex officio members, maximum of four members of the Union Council of Ministers nominated by the Prime Minister. Maximum of four. And it has a CEO who is appointed by the Prime Minister, but important fact is he or she will have the rank of the Secretary to the Government of India. These facts related to Niti Aayog are very, very important. You can expect a question on Niti Aayog because it is the 10th anniversary of Niti Aayog. Clear? Okay. Now let's look at Election Commission of India and its link with representation of the people. And this is related to disqualification. And what is this disqualification? If you are a legislator, can you be disqualified from being the member of the House only if you have been convicted by the court of law and sentenced to a jail term of 2 or more years? Is that the only ground on the basis of which you can be disqualified? No. Because Representation of the People Act 1951, it has a section called Section 8 Clause 1, 8 Clause 2, 8 Clause 3, which means if a legislator has been convicted under Section 8 Clause 1, even if only a fine is imposed, just fine, you're disqualified. If you have been convicted under Section 8, Clause 2, if you have been sentenced for a prison term of 6 months or more, only then you are disqualified. But if you are convicted for those offenses which are neither under Section 8, Clause 1 nor 8, Clause 2, you are convicted under Section 8, Clause 3, then the minimum jail term should have been 2 years or more. And then you will be disqualified. And you will be disqualified for the period of your jail term. That means if you are in jail for 14 years, for 14 years you cannot contest election, plus 6 years after your release. Which means if you have been convicted by the court of law today and you have been sentenced to 10 years in jail, for 10 years you cannot contest election. And once you're released for 6 more years, you cannot contest elections, you're disqualified. Sir, what about Amrit Pal Singh and Engineer Rashid? They are accused, they are not convicted. An accused can contest election, but an accused cannot vote in the election if you're in jail. So those who are in jail, those who are in lawful custody of the police, those who are under preventive detention, you can't vote, but you can contest election. But those who have been convicted, you cannot contest elections and you are disqualified for 6 years after the release. But how is it linked with Election Commission of India? Now, if you have been convicted and sentenced to, let's say, 5 years in jail, which means for 5 years you cannot contest election, and once you're released for 6 more years, you cannot contest election. Election Commission of India has the power that it can, in writing, in written format, you can reduce the period of disqualification. But on what grounds? You have to mention that in your ground. You may not only reduce, but you may also remove the disqualification period altogether. For example, the Chief Minister of Sikkim, he was convicted for corruption cases, then sentenced to jail, which means after you're released for 5 years, you cannot contest elections. But his period of disqualification was reduced by Election Commission of India. But while doing that, it has to mention it in the writing why you are removing or reducing this period of disqualification. And recently, Supreme Court has asked the Election Commission of India, give us all these details. How many such instances have occurred where you have reduced or removed the period of disqualification? That's why this question. Consider the following statements. The Election Commission of India can reduce the period of disqualification of a candidate, but cannot remove it altogether. It can reduce, as I said, it can remove altogether as well. Both are the powers given to Election Commission. Second, while there's a law disqualifying a candidate from contesting elections, there is no law which may disqualify a citizen from voting in the elections. You tell me what is the right answer. There is a law which disqualifies a candidate from contesting elections, and there is a law, Representation of the People Act 1950, which can disqualify a citizen from voting as. And we have seen instances where Balasaheb Thackeray, where Shahabuddin, they were disqualified from voting in the elections because of some convictions. So both these statements are incorrect. D is the right answer. Now let's look at last topic, Foreign Contribution Regulation Act. Last topic. Why? Because we have covered a lot of things in Conquer Prelim. As I said, first phase, we covered current affairs of January to May 2024. Second phase, we discussed the entire BEAR Act. And I can say this with confidence, if Prelims 2025 questions are dominated by the static portion of your syllabus, then you can attempt every such question by attending those three BEAR Act lectures. In third phase, we discuss PYQs. In fourth phase, we are discussing current affairs of the last 1 year. If we would not have covered Bare Act, then the duration of this session would have been 10 hours. We may have covered it in 4 classes or 5 classes. But since we have already discussed Bare Act, we need not waste our time in covering current affairs separately without linking them with the static portion. That's why limit your current affairs consumption. Just focus on this lecture. It is not possible that everything will be asked from this lecture. But whatever will be asked, you can use these lectures as the basis, also the plus classes. You can use these lectures as the basis to answer those questions. And we will come back. I will come back in the fifth phase and discuss various other important concepts for your prelims examination. And if you have any suggestions, what are the topics that you want me to cover in the fifth phase, please let me know in the comment section or let me know in my Telegram channel. I will do that. Okay, great. Let's look at Foreign Contribution Regulation Act. It was initially passed during 1976, first as an ordinance when emergency was in place. But then this law was repealed in 2010 and a new law was passed. Then this law was amended significantly in 2020. And recently, some rules were also changed. That is why FCRA becomes important. For example, if you have raised money through foreign donations, you can spend this money for 4 years. Recent change which has taken place. That's why FCRA becomes important. But what were these changes? First, there are certain categories of people who are barred from receiving foreign contributions. For example, as I said, when in 1976, during emergency, this law was passed. At that time, any criticism of the government, the then government headed by Indira Gandhi would say that there is a foreign hand involved in it. That means CIA and other countries, they are trying to destabilize India. So foreign money, foreign contribution can be used to instigate protests in India, to destabilize the government. Clear? That is why the need was there to bring in FCRA. So certain people were prohibited from accepting foreign contribution. Who were these people? For example, judges. For example, candidates contesting elections. Similarly, publishers of newspapers, magazines, cartoonists, editors. But in the year 2020, public servants got added. That means now public servants also cannot receive foreign contribution. They're prohibited from receiving foreign contribution. That's point number one. Point number two, transfer of foreign contribution. If you want your NGO or your university or a college to be eligible for foreign contribution, to be eligible for receiving foreign contribution, you need a license, FCRA license as we call it. And this FCRA license is given by the Home Ministry. Home Ministry is responsible for. And this license is valid for 5 years. Clear? For example, X was also eligible. X also has a FCRA license. Y also has a FCRA license. Money is received by X. X could have diverted, transferred some part of this foreign contribution to Y because both were eligible for foreign contribution. In 2020, this was stopped. If you are eligible for FCRA, you have received foreign contribution, you cannot transfer it to any other entity, even if that entity was eligible for FCRA. Third, in 2020, the law which was amended by the parliament, it made it mandatory that this organization or this university or a college or this NGO, if it wants to receive foreign contribution, it has to give Aadhaar of all key functionaries. All the office bearers, all the directors, all the key office functionaries, you have to provide Aadhaar to the government. Fourth, previously, if your organization was eligible for FCRA, you have the FCRA license, you could have nominated, you could have suggested any bank account of your choice in any bank, in any state, in any branch where you could have received the foreign contribution. In 2020, the parliament said, no, we will specify, the government will specify, the central government will specify, Home Ministry will specify which branch of State Bank of India you will have to open the account in, and you can receive foreign contribution only in that account. And later on, rules were made where it was made mandatory that all the entities who want to receive foreign contribution should open the bank account in State Bank of India, Parliament Street branch, in which you can receive the foreign contribution. Fifth, previously, whatever money you have received as foreign contribution, you could have spent 50% of this for administrative purposes. That means for rent, for salaries, for various other administrative purposes, you could have spent this money. 50% of foreign contribution could have been spent on administrative purposes. Now, in 2020, this got reduced to 20%. Now, only 20% can be used for administrative purposes. The remaining 80 for the purpose for which you received this foreign contribution, whether it is for health purpose, education, sanitation, whatever. Previously, the law said if this FCRA license is suspended, it should be suspended for 180 days. In 2020, amendment said if first it is suspended for 180 days, it can be further suspended for 180 more days as well. Last important point. If your FCRA license is valid for 5 years, within 6 months of the expiry of this license, you have to ask for renewal. Otherwise, you will not get renewal. But when you will ask submit application for renewal, the central government may conduct an inquiry. Inquiry why? To see that if this entity is fictitious or benami, then we will not renew your FCRA license. If this entity was convicted for creating communal tension, because the allegation is that this foreign contribution is used by some NGOs and they want to convert Indians into Christianity. So if this money you have received and you are using this money to convert people into another religion, then we will not renew your FCRA license. And lastly, if you have diverted this fund, misutilized this fund, for example, you could have spent only 20% on administrative reasons and you are spending more than that. That means you're misutilizing the funds or you are diverting these funds to another entity. Then in that case, your FCRA license not be. These are the 20 topics that we had to cover today in the fourth stage of Conquer Prelims. If there are some topics for which you need clarity, if there are some concepts for which you need some clarity, if there are some areas of the polity syllabus for which you need clarity and you want me to cover those areas in the fifth phase, do let me know in the comment section. But please focus on revision. Whatever you have read, focus on revision. Focus on as much revision as possible. Take as many mocks as possible and be confident. Prepared hard, prepared well. There is no power on earth that can stop you from cracking the prelims. Thank you so much for staying with me on Friday evening. I hope to see you soon. Till then, a great time. All the best. And do not forget to press the like button as well. Bye bye. Good night.